Good morning, members of the court. My name is Jervis Wise, and I represent the appellant Stephen Pinero. And I would like to reserve 5 minutes for rebuttal, if I may. Members of the court, we've raised two issues, as you're certainly aware. The first I'd like to address is the trial court's preclusion of Mr. Pinero's expert witness. Decades ago, the Supreme Court said in Chambers that there are few rights more fundamental than that of an accused to present witnesses in his own defense. The trial court, unfortunately, precluded Mr. Pinero from doing that. And I believe in doing so, the court mistook concerns the state raised, which really I believe were questions of the weight of the testimony, issues that the state could have explored in a cross-examination, and mistakenly found instead that these were issues of admissibility.
Well, did the trial court find that the testimony would be confusing to the jury?
I believe that was one of the trial
Is
court's.
that a discretionary call or a matter of law? You still have the right to call your own expert.
I believe in this situation it's a matter of law. And I believe that for a couple of reasons. One, really it becomes a constitutional issue that goes back to Chambers when the court precludes the witness altogether. I agree there may have been some areas where the court could have limited the expert's testimony if it went too far afield from the issues at hand. But in this case, the court precluded the witness altogether. And the other reason I say that it really comes down to a matter of law is the court, in doing so, rejected a case from the First District Court of Appeal that was directly on point. I would suggest...
Is that the Clemens case?
Yes, Your Honor. And I would suggest that Clemens was materially indistinguishable from the case at hand.
Clemens was in a different procedural posture.
It was.
And so the holding in Clemens is that the circuit court's order that the evidence should have been admitted did not depart from the essential requirements of the law. Right? Clemens did not hold that the county court abused its discretion in refusing to admit the expert testimony. Right?
No, Your Honor. And I believe that was part of the trial court's reasoning for rejecting Chambers. It's because it was second-tier certiorari review. But reading Chambers, which is a pretty succinct opinion, they go beyond merely just endorsing the circuit court appellate opinion. They go on to say that it was the circuit court's ruling was far from a departure from the essential requirements of the law. Indeed, it was in conformity with the essential requirements of the law. It goes on to state the quote from Chambers that I actually just read, and it goes on to state that any relevant evidence tending to even establish reasonable doubt must be admitted. It goes on to add that if there's any question, it has to be resolved in the favor of the defense. So I would suggest, yes, it was decided on second-tier certiorari review, but clearly the first DCA agreed with the circuit court. I believe reading the opinion indicates that the first district would have decided it just the same had it reached them on direct appeal, first-tier direct appeal.
And nothing would preclude us from reaching the same conclusion if it is here on direct appeal, but for purposes of whether it was binding on the trial court at that time. Is it your position that it was binding under the Pardo, or?
I believe it was.
It's certainly persuasive, but is it binding?
I believe it was, Your Honor. And as particularly when you read into the opinion and the statements that the DCA makes, and given that there's no other DCA opinion that's contradictory whatsoever with Clemens. So I recognize, again, it was a different district court of appeal, and it was second-tier certiorari, but I believe it was still binding on the circuit court under the circumstances.
Do you have any case law that stands for that proposition?
I do not, Your Honor. I do not. Additionally, looking at the facts, I believe clearly indicates that the circuit court that addressed Clemens and the first DCA that addressed Clemens were dealing with a situation exactly like the situation that the circuit court was dealing with in this case, or the county court rather. The county court mistakenly, I believe, thought that Clemens was about the .08 theory of prosecution. And Clemens doesn't address it in detail, but it does state clearly that the defendant in Clemens was charged under section 316.1931A, which is the normal faculties are impaired, the same exact theory of prosecution that the state proceeded on in this case. So unfortunately, the county court, and one of her reasons, besides the second tier certiorari review, but her other reason for rejecting Clemens was because she apparently mistakenly believed that Clemens involved the 0.08 presumption or that theory of prosecution. It clearly didn't. Just like Mr. Pernero's case, the state proceeded there on normal faculties are impaired.
And it's not just normal faculties are impaired. The state still has a burden of showing that the defendant's under the influence of alcohol, right? Even if there's no reliance on the presumption.
Certainly. I think really the two theories of prosecution are just means of proving the same allegations. Really, did the defendant drive while impaired? And the reason that's important is because the proffered defense expert presented evidence to the contrary to suggest that even though these officers saw what they believed were signs of impairment, there were reasons for those signs. And when he extrapolates out what Mr. Pernero said he had to drink over the timeline, it would show that he was not impaired. And he goes even further in his proffer by saying that he had reviewed the videos. He essentially saw everything the officer saw. I guess perhaps maybe not all of the driving, but other than that, he saw the same things the officer saw.
Well, he said he's not impaired, but is it that, he might have been impaired, but it's got to be under the influence of alcohol, right?
Yes.
That's really the key, because if he was having some health crisis or something like that, then that statute would be inapplicable.
Absolutely. And you bring up a good point. There were signs of impairment, clearly, but this expert would have helped establish that those signs of impairment could have been from the tremors and the liver disease that he also suffered, which the court didn't allow in, but it was because he had served at Camp Lejeune many years prior and had these conditions unrelated to alcohol. So the expert could have explained all that, could have provided a potential for showing there's reasonable doubt as to whether he was impaired under the circumstances. And based on Chambers and the many, many cases that have followed it, I believe the trial court went too far in precluding the expert and precluding Mr. Pernero from presenting that critical evidence. And if the court has no other questions on that issue, I will move on to the second issue we raised, which is the denial of the motion to suppress evidence of the refusal to submit to the field sobriety test. This is a situation, members of the court, where I would suggest Mr. Pernero was not advised of the actual consequences of the refusal. He certainly was not advised that it could be used against him if he refused. The closest the officers came to suggesting he would be arrested if he refused is by stating at one point that they would have to go off the observations they had seen. Unfortunately, they went further and made many other statements that I believe suggested to Mr. Pernero that this was, as the Neville court had stated, a safe harbor that was free of adverse consequences. Basically, they led him to believe that he had the option to just choose not to take the test.
And they said, we're trying to be fair to you.
Which sort of reinforces that,
Hey, that's your shot. You can show us that you can pass these tests and we'll be good to go. But if you don't do that, if you refuse to do that, we're going to have to go off our observations. So clearly there are negative consequences to not taking the sobriety test.
There, arguably so, yes, sir. I believe with looking at the totality of the statements they make, the officers, it comes to the point where they're leading Mr. Pernero to believe that, yes, they're trying to help him and they're giving him this opportunity that he doesn't have to take, leaving him to believe it's a situation essentially where he has no adverse consequences. If he doesn't, it's up to him. During the interaction, the arresting officer says it's up to you. That's before he even makes the statement about we have to go off what we see. He goes on shortly thereafter, and that's when he says, here's the thing, I have to go off my observations and your actions if you refuse to do the field sobriety exercises. But then shortly after that, he specifically tells Mr. Pernero, you're not under arrest. They go on to say, we're not forcing you to do anything, we're trying to be fair to you. State a couple more times a different deputy that we're trying to be as fair to you as we can. And at no point is it ever told to him, if you don't do this, it will be used against you. And if you don't do this, we're going to arrest you based on what we've seen. They say, we're going to go off what we've seen to this point and say many, many times we're trying to be fair. I believe under the circumstances, given the totality of the circumstances, it's a situation where Mr. Pinero is led to believe nothing will happen adversely if he chooses not to do this. That the officers are giving him this opportunity to help himself and he doesn't take it. I believe that that is similar to the situation at issue in the Mana case. I would also acknowledge that the facts of the Taylor case, the county court relied on, were very similar. Some of the major differences, though, is that in Taylor, the Florida Supreme Court had stated in the opinion that the officer at some point told the defendant that he would be arrested if he did not, or that he could be arrested. Also in Taylor, the facts don't indicate that the officers went further than as the officers did in this case by repeatedly saying it's up to you. We're trying to be fair to you, leading him to believe it's a safe harbor. And I think what's also important is that Taylor was decided prior to the Mana case, which I believe somewhat changed the way of looking at this, because in Mana, as in I believe this case, the court seemed concerned with the fact that the law enforcement officers were leading the defendant to believe that submitting to the test was optional.
Well, in Manham, when the defendant didn't submit to the test, they just left the hotel room. And they didn't spring a refusal on him, or what was it, she, until the actual trial.
Yes.
Whereas here, he didn't do the test, they went off their observations, and he was arrested right there on the spot. So there was no surprise at trial like there was in Manham.
Certainly not. There was certainly no surprise, and they brought this up in a motion to suppress pretrial. So it was certainly that Mr. Pinero was aware of it. But I believe why Mana is controlling in this situation is just like Mana, I would suggest what the officers do with their additional statements is they lead Mr. Pinero to believe that he has the option of just choosing not to do this. And unfortunately, that's the option that he took. The Howard case, which followed Mana, was a similar situation. Now, in that case, the officers, I believe, didn't even go far enough as to say that they would have to go off their observations to this point. But clearly, the Howard case endorsed Mana, and I believe had the same concerns that the Florida Supreme Court had in Mana. In the end, Mr. Pinero was not advised that he would be arrested or that the refusal would be used against him. And I believe under the circumstances, it could not be admissible as consciousness of guilt. If the board has no other questions, I'll take my seat.
Great, 5 minutes.
Thank you.
May it please the court. Good morning, your honors, counsel. My name is Nicole Rochelle Smith. I'm appearing on behalf of the appellate state of Florida. I'd like to start out by first addressing Judge Ballstein's your question regarding Clements. The Clements case is not binding precedent. Specifically in Shapps v. In a 2002 Florida Supreme Court case, Shapps v. Provident Life and Accident Insurance Company, in the context of a denial of certiorari, which was the case with Clements, cert was denied. The Florida Supreme Court said, while it is so well established as to not require explanation, we point out here again that denial of cert by an appellate court cannot be construed as a determination of the issues presented in the petition and therefore cannot be utilized as precedent or authority. So I just wanted to start out by highlighting that the Clements case is not binding authority on this court. With respect to the first issue, the trial court did not abuse its discretion by granting the state's motion in limine to exclude this expert testimony. This testimony was not relevant because the state was proceeding on the basis of normal faculties impaired, and therefore the 0.08 blood alcohol level was not an element of this charge.
But the state still had to prove that he was under the influence of alcoholic beverages. So how is the testimony of an expert that, given what he supposedly had to drink that night, there is no way a person of his weight, height, etc., would have been under the influence of alcoholic beverages at that point? How is that not relevant? I'm having a really hard time understanding that argument.
It's not relevant for two reasons. Well, this testimony was properly excluded for two reasons. It wasn't relevant because the state was not proceeding under the .08 blood alcohol level. The state was proceeding under normal faculties impaired. The jury would have absolutely no context for why this testimony was being proffered in the first place. There was no mention of blood alcohol concentration levels whatsoever. And this testimony would thoroughly confuse and mislead the jury. And the key here in this particular case is this expert's testimony was relying basically only on self-reported alcohol consumption by.
But that goes to the weight of it, and that could have been cross-examined on. I mean, what I don't understand, the expert would get up there and say, based on what he had to drink, based on my analysis, which nobody challenged, there's no Daubert issue here, he was not under the influence of alcoholic beverages at that time. There doesn't need to be any reference to the presumption. Any reference to blood alcohol level would have been purely incidental to his explanation of his methodology. And frankly, that's what experts are for, to explain that kind of thing. So how is it irrelevant? And given a limitation to avoid reference to the presumption, because that's not what we're talking about here, how is this confusing to the jury?
It's confusing to the jury because this type of retrograde analysis testimony, the basis of retrograde analysis testimony is where there was a sample provided. This expert had absolutely no baseline. He had no starting number to work backward.
But that wasn't the objection. Once again, there was no Daubert challenge. You all said, yeah, he's an expert in this. This is fine.
But the key in this particular case is there was no sample provided. So his testimony was.
That's the whole nature of the Widmark analysis, which you all did not object to, correct?
Correct, but this Widmark analysis was based on this Mr. Penar's self-reported information.
And
all the other cases,
that's the basis for cross-examination.
all of the other prior cases where this type of testimony was admissible, there was a sample taken. In this case, in the Barber case, which Judge Villanti authored, all of those cases involved testimony where there was a sample taken in the first place.
That's a completely different analysis. That's retrograde analysis. And obviously that's well accepted. But you had no problem below, or trial counsel had no problem below, with the Widmark analysis. That wasn't the basis for excluding it. The basis was that it was irrelevant and confusing, not that it was scientifically unsound. That's a completely different argument than varies below, than argued in their briefs, in your brief rather. So based on the argument in your brief, why is it irrelevant and why was it confusing?
It's irrelevant because the state is not proceeding on this. This expert went on a lengthy lecture about this whole Widmark formula and retrograde analysis. The jury would have no instruction on what any of this means, and it would confuse them. And that is the position that the state takes in this case. It was irrelevant based on this specific charge of normal faculties impaired, and because in this case, unlike all the other cases where this type of testimony was admissible, there was no sample taken. So it is the state's position that the trial court did not abuse its discretion by excluding this testimony, by correctly recognizing and evaluating the rules of evidence and determining that this testimony was irrelevant. And in this particular case, under these specific facts, where the state was proceeding under normal faculties impaired, and the fact that this defendant did not provide a breath sample, this testimony would confuse and mislead the jury. And to allow such testimony would almost eliminate the state's ability to prosecute these type of DUI refusal cases where a defendant can simply refuse all tests and then hire an expert to say, I don't think he was impaired.
And that's what you say in closing argument.
Unless the bench has any other questions regarding this first issue, the state's position is that the trial court correctly decided that this testimony should be excluded and the trial court did not abuse its discretion, so we respectfully ask the state to, the bench to affirm. With respect to the second issue, again, the trial court did not abuse its discretion by denying the appellant's motion to suppress evidence of this refusal. Your Honors, you have the same exact body cam video that the trial court had, and you can see that this defendant was advised of the signs of impairment that the officers observed. He was asked to perform these field sobriety exercises. The Deputy Spencer explained that these were specifically DUI exercises that he was asking him to perform. He requested a lawyer. It was further explained to him, you're not entitled to a lawyer at this point in time. We are conducting an investigation. And Deputy Cross explained that if you perform these field sobriety exercises, it will assist us in our investigation. It's clear that this defendant, who has 2 prior DUIs, was aware of the adverse consequences of refusing to submit to these field sobriety exercises. He also admitted at trial that he was aware that he would be arrested that night. He was specifically asked by his counsel, did you think you would be arrested that night? And he said yes, by failing to perform these field sobriety exercises. Therefore, again, the state respectfully asks this court to affirm. The trial court did not abuse its discretion by denying the appellant's motion to suppress evidence of his field sobriety exercises. And unless the court has any further questions, thank you.
Guys, you got it.
Thank you, Your Honor. Please, the court. And in response, leaving off with the second issue the state just left off, I'd like to make a couple of arguments in response. With regards to Mr. Pinero's prior convictions, I believe the state acknowledged they were remote in time. I believe one was in the 80s, one was in the 90s. I don't believe that bore on the issue at hand and the motion to suppress. The other thing that I think is important to point out is that when this came up during his testimony, Mr. Pinero's testimony about whether he believed he was going to be arrested or knew he would be arrested, that was during the trial. That was not before the court when the court ruled on the motion to suppress. And I believe had the court ruled correctly on the motion to suppress, that testimony would have never come out in trial. Cycling back to the first issue, I would briefly point out with regards to the question of whether Clemens was binding, I recognize the Supreme Court's holding that the state mentioned, but I would also point out that oftentimes when certiorari is denied, nothing is stated by the court. And of course, that kind of opinion would not be binding. The reason I suggest Clemens is the court, the first district, went much further in Clemens and gave its reasons why it was denying certiorari and why it agreed with the circuit court. And then just to state briefly, the evidence that the court precluded, the witness's testimony, was relevant to show that Mr. Pinero's normal faculties were not impaired at the time. And he had every right to present testimony to that effect. To the court's concerns that it could have been confusing or could have limited testimony, I agree that because the state was not proceeding under the .08 theory of prosecution, some of the expert's testimony may have gone too far afield, and the court could have limited that. But unfortunately, the court didn't limit the testimony. It precluded the witness altogether. One of the reasons I had cited, and I don't believe we discussed it, but the Tello case that this court had addressed recently was because, one, it I think acknowledged the reliability of the Winmark calculations and that sort of testimony, but it also noted that because there were questions of accuracy in that case, of the accuracy of the testing, the court specifically stated that's a question of weight, not admissibility. And it's something that the state can address on cross-examination. And that's essentially the same issue we had here. And unfortunately, the court precluded the witness altogether rather than potentially limiting some of the question or some of the testimony and allowing the state the opportunity to address it on cross. I would also point out, members of the court, the state has every opportunity to present an expert witness just as the defense does. So if they believe the defense expert was incorrect in his findings or somehow it didn't have the weight it should have had, they have every opportunity to present a witness who might say the opposite if they can find one who would say the opposite. But unfortunately, it didn't get to that point because the trial court precluded it altogether. And I believe the heart of the issue is the trial court mistake questions of weight for questions of admissibility. And if the court has no other questions, I'll take a seat.
Thank you. We'll move on to the next case, which is Florida Homeowners Equity and Lost Property versus Fairfield.